students, I hope you are doing okay in this period of quarantine. We at IMS Noida try to imbibe the culture of continuous learning, even though we are at our homes, but we must not forget that the learning should not stop. So in continuance of that, we are holding such online classes and lectures so as to help our students to continue their journey of evolution through learning. So today we will be discussing about company law. Now company law, this class will give you a brief idea about what a company is and how a company is different from other forms of business organizations such as partnership firm, cooperative societies. There are other business organizations, sole proprietorships, other Hindu undivided family business organizations are also there. So how a company is different from that and what a company is. So you will get by the end of the class, you will get an idea about what a company is all about, right? So first of all, we will be discussing about the meaning of a company. When we talk about a company, we cannot leave behind the Companies Act, because under company law, Companies Act is very important. You must know the important provisions of Companies Act 2013. Companies Act 2013 has been recently passed. Before that, there was Companies Act 1956, and before that it was Companies Act 1913, right? So when we talk about the meaning of a company, company means, in simple terms, you can understand it's an organization or association of people who have come together for a common object or purpose. It could be anything. Generally, people think that company means an organization who works for the purpose of earning profit. It is not so. There are a lot of non-governmental organizations, charitable institutions, educational institutions, which are also considered as companies. So we must always remember that company does not mean that it must earn some kind of a profit. It is not necessary. So if we see, company means an organization of people, like suppose 5 people are there, right? So when we club together these 5 people in a group, and these groups share the same object or vision, then we can say that it is a company. In layman terms, you can understand this is what a company is. Company, the word, the terminology, if we talk about the terminology, it comes from 2 Latin words, that is cum plus panis, that is coming together for earning bread. That means earlier, when they were trade organizations or trade associations, they have come together as a modern day corporation to achieve a common object of not only the benefit of their members but also for the benefit of the society by doing trade and commerce with the common people or with different countries. So it is a Greek Latin word, coming together for earning bread. That is the meaning of a company in layman terms. Now when we talk about इसको edit कर देना एक मिनट, नहीं बंद नहीं हुआ है, गिर गया ये, एक मिनट, अब ठीक है, हाँ. Now in layman terms it is club of people who share common object or vision. Earlier there was Companies Act 1913 during the British era. Then they came Companies Act 1956. It was passed on the recommendation of C.H. Bhabha Committee. And after that, when globalization, privatization happened after 1991 in the government of Narasimha Rao, when Manmohan Singh was finance minister, lot of changes happened in the Indian economy. The Indian market was opened for FDP, foreign direct investment, and FII, foreign institutional investment. So it was very necessary to change, to overhaul the Companies Act 1956 in tune with the current times. Therefore, there were a lot of recommendations after 1991 to amend 1956 Act. Later on, it was felt that it is better to remove or to repeal the entire act itself and to formulate a new act which could incorporate the current trend, or which could be contemporary in tune with the present era of globalization, privatization and liberalization. That's why the Companies Act 2013 was passed. Companies Act 2013 introduced a lot of novel concepts like independent directors, CSR, corporate social responsibility, women directors, postal ballot, which we will discuss in the later classes. So when we talk about company under Companies Act 2013, we must remember that just a group of people who have come together for a common object or common vision will not be considered as a company under Companies Act 2013. So in order for a company to be considered, गिर जा रहा है, इसको कैसे हाथ पे ले, इसको पीछे डाल सकते हैं क्या? पीछे डाल देता हूँ ना, इसको रख देना, रुक जाओ, इसको पीछे रख देता हूँ, शायद तब नहीं गिरेगा, कि यहाँ तो गिर जा रहा है, अब ठीक है, मुझे लगता है अब नहीं गिरेगा, है ना? So when we talk about company under Companies Act, when we talk about company under Companies Act 2013, a group or association will not be considered as a company, because when we see a group or association, suppose there are 5 people, it is not necessary that it should be a company, even if they share a common object or vision. They may be partnership firm, cooperative society, or it may be any form of sole proprietorship, it could be anything. So what a company is under Companies Act, the definition makes it very clear. When we talk about the definition of Companies Act is given, definition is given under section 2 clause 20, which says that company means a company which is incorporated under the Companies Act. That means even if there is a corporation or association of people, it will not be considered as a company, even if they share the same object or purpose, unless they are registered under the Companies Act. So registration is very essential in order for an association to be called as a company under Companies Act 2013. Now that we have understood what a company is, let us discuss certain definition given by jurists and legal experts in order to have a better understanding about the meaning of a company. So according to Lord Justice Lindley, According to Lord Justice Lindley, a company is, according to Lord Justice Lindley, a company is association of many persons who contribute money or money's worth to a common stock and employ it in some trade or business, who share the profit and loss arising therefrom. The common stock so contributed is denoted in money, is the capital of the company. The person who contribute it or whom it belongs are members. The proportion of capital to which each member is entitled is his share. Shares are always transferable, although the right to transfer them is often more or less restricted. So if you see the definition, it is quite comprehensive. If you read it carefully, you will get a brief idea about how a company works and what a company is all about. So you have to remember that if there is a company, if there are 5 people in a company, some people will spend 2 lakhs, some people will spend 5 lakhs, some people will spend 7 lakhs, some people will spend 1 lakh, some people will spend 9 lakhs. So when we club together the entire capital invested by the members of the company, it will be considered as the capital, overall capital of the company. And on the basis of the investment made by the shareholders, equal amount of shares will be issued to the shareholders, and they will be called as the shareholders of the company, and they will be part owners of the company, and the amount of capital that they have invested in the company, their liability will be limited only to that extent. So you can say that the capital of the company is the investment that is made by individual shareholders in the company, and the business or the profit that is been made by the company will be shared by the shareholders of the company in proportion to the money that is been invested by the shareholders. Now that we have understood what a company is, how a company operate, let us discuss about the nature of the company in order to have a better understanding about the entire mechanism of the working of the company. Now, when we talk about the nature of the company, the first feature of the company will be an incorporated association. Incorporated association. When we talk about incorporated association, it means that if a association or group of individuals wanted themselves to be considered as a company under the Companies Act, they have to get themselves registered. Until unless they are registered, they will never be considered as a company under the Companies Act. Now, there are certain limitations also which we have to discuss. Suppose there is a group or association of people of strength of 50. Now, if they register under the Companies Act, then there is no problem, they will be considered as a company. But suppose if they don't register under the Companies Act, then what will happen? Suppose the strength is 50 plus 1, that is 51. So if this association of people who are sharing a common object does not registered under the Companies Act, then this association will be considered as an illegal association of people, because the Companies Act specifically says that any association of more than 50 people must be registered under the Companies Act, otherwise they will be considered as an unregistered partnership or illegal association, and it will not be considered as a group or association who could carry on their business in the eyes of the law. So section 464, if you read section 464 of the Companies Act, it clearly says that any association of 50 plus members, 1, 2, 3, any number, must be registered under the Companies Act. They cannot run their business unregistered. Now the next point is artificial legal person. Artificial legal person. When we talk about artificial legal person, you must understand that company is not a natural person, because natural person is something who's taking breath, who has been born into this world out of her from the legal wedding or some way he has been born into this world. In order to be considered as a natural person, he must be some living human being. But if we talk about company is a legal person, not a natural person, because when the company is registered under the Companies Act, it is granted a legal entity. Since the company is a legal person, it can own property, it can sell property, it can be sued, it can sue, and the property of the shareholders or the members is different or is separate from that of a company. That means the capital of the company will be different, capital of the shareholders will be different, they will not be intermixed. So always remember, the company has a separate entity and it is a separate legal person in his individual capacity. However, we know that a person cannot work without its brain. So how a company will work? Company will work through its brain, and the brain of a company is its board of directors. So always remember, friends, that the company takes all its decisions through its board of directors. Board of directors are the elected representative of the shareholders, and they take all the major decisions of the company on behalf of the shareholders. Because in a company, suppose there are 10 lakh shareholders or 1 crore shareholders, all the shareholders cannot meet and decide for the company. So what they do is that they elect a board of directors or their representatives, and these representatives take important decision on behalf of the shareholders of the company, and they are called as, they could be called in layman language as the brain of the company. So always remember, friends, the company works through its board of directors, who are elected representatives of the shareholders. Now, what is the third feature of a company? Third feature of a company is separate legal entity. Separate legal entity. What is the meaning of a separate legal entity? Since we have studied that company is a legal person, since it is a legal person, it has identity which is different from its shareholders. So if a company, suppose a company hold 10 crores of capital, so this 10 crore is not of shareholders, it is of the company, and it can be used in any way for the purpose of business of a company. When the company is dissolved, when the company is being wound up, then the picture of capital of the company comes into effect, and then when the liquidation is done, then all the shareholders are called upon to contribute the amount which is not been contributed by them on their behalf, so that the liquidation of the company could be done, which we will discuss later. But always remember that the company is a separate entity, company has a separate capital, company has a separate separate entity which is different from its shareholders. Always remember, there is a wall between company and its shareholders. Identity is entirely different. Always remember. Now the third point that we will be discussing is perpetual succession. Perpetual succession. What is perpetual succession? The fourth point that we need to discuss is perpetual succession. Perpetual succession means, perpetual means never ending. That means, suppose a shareholders of the company and directors of the company, due to some mishappening or due to some accident, all of them died, none of them is left. So does that mean that the company will cease to exist? No. Company, always remember, company is a separate legal person. So even if all the shareholders, all the members, all the directors of the company die, that does not matter, because since the company is a separate legal person, some other person will be appointed as the manager or the shareholder of the company, and the company business will continue. So even if the members die, even if the members retire, even if the members leave the company will never be affected, and it will continuously go on as long as the company is being dissolved according to the provisions of the Companies Act. So always remember, friends, company when registered under the Companies Act come into being, it is like a birth of the company, and similarly the company cannot die a natural death. The company has to be wound up, the company has to be dissolved, the company's accounts have to be satisfied, the company account books has to be closed in order for a company to be in order for the lifetime of a company to come to an end. So always remember, until unless the company is dissolved under the Companies Act, the company will always have a perpetual existence, a perpetual succession. One member retires, another member will join. One member will retire, other member will supersede, other members will continue. Now, the next point is about limited liability. The next point is about limited liability. Limited liability. What is the meaning of limited liability? Friends, this is the single most important aspect of a company. This is what makes the company predominantly different from a partnership firm or any other form of business organization. When I say that, suppose in a company there are three people are there, one person has invested 2 crores, another person has invested 1 crore, another person invested 2 crores. So always remember that these investment will be equal to their liability. So one person will be liable only up to 2 crores. Another person who has invested 1 crore in a company will be liable only up to the amount of 1 crore. And and the person who has invested another 2 crores will be only liable up to the amount of 2 crore, not more than that. Suppose the entire capital of the company is 5 crores and the company incur a loss of 10 crores. So does that mean that the rest 5 crores which is in deficit could be recovered from these members? No, because the liability of all these 3 members is limited to the investment that they have made in the company, which is only 5 crores. So 5 crores could be recovered by selling the property, assets, or through any other means. The property will be recovered and the creditors will be paid their amount in the through the some other means by the through the channel of company. So always remember that the shareholders of the company liability is only up to the extent of the investment that they have made in the company. But in other forms of business organization, when we talk about partnership firm, the partners are unlimited liable. That means if a partner has invested 10 lakh rupees in a partnership firm, his investment will never be up to 10 lakh. It could be up to 1 crore if the partnership firm incurs a loss of 1 crore, because their liability is not limited, but their liability is unlimited. So these are certain attributes which makes the company or its operation different from other forms of business organization like limited liability partnership, partnership firm, sole proprietorship, these all things. Now, and the last point that I want to discuss is about the transferability of shares. Limited liability, when we talk about limited liability, one more thing that we have to discuss is liability is limited by shares and the liability is limited by guarantee. When we talk about liability limited by shares, that means the amount that you have invested in a company, the amount of shareholdings that you have that you are holding of a company, your liability will be limited only to that extent. Suppose in Reliance Corporation I have invested 1 crore rupees and I am holding 10,000 shares, then my liability will be up to the amount of 10,000 shares, that is 1 crore rupees. In the liability limited by guarantee, generally this type of liability is in case of not-for-profit making companies like educational institutions, charitable institutions, non-governmental organizations, NGOs, etc. In that case, in such kind of organization, there is no shareholdings or investments. What the people do is that they club their capital investment in that particular company, and the company and the members of the company guarantee that at the time of the winding up of the company, whatever the losses that has been incurred will be shared by the members. So suppose in a company that is an NGO, non-governmental organization, the NGO suffers a loss of 5 crores. So if there are 5 members, so members might agree that 1 crore loss will be shared by all these 5 members. So their liability will be limited to the guarantee that they have made, that at the time of winding up of the company, they will guarantee the amount that they will pay at the time of dissolution of the company so as to satisfy the claim of the creditors. And the last point that I want to discuss is about the transferability of shares. It's about the transferability of shares. So when we discussing about the transfer and transferability of shares, what is transfer of shares? That means shares is a movable property, so it get transferred from one person to another. Transferability means involuntary transfer. That is, if a person dies, if a person becomes insolvent, if a person leaves the country, then automatically the shares of one person gets transferred to another. So in case of transfer of shares, if A wants, he can transfer his shares to B or any person. In case of a publicly limited company, if he is trading, because the shares of a publicly limited company are being traded in stock exchange. So in stock exchange, one person can sell his shares to B. So any person, A, B, C, D, any person can share his shares to another person, transfer his shares to another person. In case of transferability, what happens that it is an involuntary transfer of shares. So if A dies, then his son, wife, legal heir, successor will get the shares automatically. Or if A becomes insolvent, then the creditors will sell his shares to some other person. So it is an insolvent process. It is an involuntary process in which the shares get transferred. So that being said, we have covered the topic of meaning and nature of a company, and I hope that you have understood the concept of meaning and nature of a company. In the next class, we will be discussing about the promoters of a company. Who is the promoters of a company? Thank you so much for patiently listening. Thank you so much.